5, 4, 3, 2, 1.
Oh yay, oh yay, oh yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning and welcome to the Tennessee Court of Appeals. I want to first of all thank each of you for participating in this oral argument via Zoom. It is a method that we've utilized since the pandemic, and we found it to be very useful, and we appreciate you all agreeing to participate with us in it. I will caution everyone. I think caution is probably not the right word, but I will tell everyone that we will conduct ourselves as if we were in the courtroom all together. The same procedures, the same protocols will apply. Each side will get 15 minutes to make its oral argument, and if you are the appellant and have reserved rebuttal time with Mr. Hibner, you will receive that rebuttal time as well. Before we get started, though, I'd like to introduce your panel for this morning. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case then.
David Thacker versus City of Greeneville, Tennessee et al.
And we will hear from the appellant.
Sorry, Your Honor. We're adapting to Zoom arguments. This is my second one, but we'll do the best we can. My name is Gerald Tidwell. I'm a member of the Hamilton County Bar for 38 years. Present in the room with me is my associate, Matt Tidwell, who's also my son, a recent admittee to the bar, who just wants to observe, and Vanessa Campbell, who's an attorney in my firm, who wanted to observe. I will be brief. I represent David Thacker, a former Greeneville police officer who was terminated. He was terminated for an event that occurred while he was a dispatcher, which I will address in a moment. But just very briefly, the standard of evidence, I think, is the question of whether substantial material evidence exists to terminate him, and if his termination was arbitrary and capricious. Those are the only two issues I intend to address. As I cite, substantial material evidence is the amount of relevant evidence that a reasonable mind might accept to support a rational conclusion. It furnishes a reasonably sound basis for the decision. We simply assert that is absent here. Mr. Thacker was a 20-year police officer who was placed at the dispatch level, probably because of his diabetes issues, but in any event, he was dispatching. A man called in and said a person had hit him with the mirror of their F-150 Ford pickup truck, silver in color, and clipped him more or less. And he was walking down the highway when it happened, and he was walking toward the hospital that exists in Greeneville. Based on what he told Mr. Thacker thought he was probably about a mile from where he had been originally struck and was very close to the hospital. He offered the man medical care and EMS assistance 3 times, and he refused. An independent witness dispatcher testified to such. The man refused medical attention. He was not at the actual scene of the hit and run, at least in Mr. Thacker's opinion, and was walking to the emergency room in an attempt to get assistance. Mr. Thacker did not put a bolo out on the Ford F-150 because he didn't feel like he had enough information. It's the most popular car in America. And even with the color, without some partial tag or some more information, he didn't think there was probable cause to pull any vehicle over. Plus, the man had walked quite a distance, so the car was long gone. Later, the man told the internal affairs investigators that the mirror had broken. It hit him so hard. Mr. Thacker doesn't recall anything like that. And here's a critical element of this. The city of Greeneville does not tape record their CAD traffic. And I have done police officer work for 30 years. I have never crossed a city or county that doesn't have a recording of their CAD traffic to the dispatcher. It's a fundamental pillar of defending civil rights suits, which I've done for 30 years. I've handled hundreds of civil rights cases involving police officers. The CAD traffic is critical to what they allegedly, the plaintiff may claim or allege, or how you defend the case.
Excuse me, counsel, is there some dispute about what was said or what the traffic actually reveals?
I think so. I think that the dispute is, did the man, the victim of this event, did he tell Mr. Thacker the mirror was broken or not? Mr. Thacker doesn't recall that. And the only thing that's introduced into evidence is a report from the internal affairs folks. We don't have a statement per se that I recall. I apologize if I'm incorrect on that. I don't recall that there's a tape recording of the statement in evidence. But in any event, Mr. Thacker chose not to bolo the matter or be on the lookout for. He had no particular, there's no evidence of any particular training or policy that he was instructed on how to handle this unusual dynamic situation. So he chose to tell the man to go into the hospital and call me and I'll send a car, which he did. He sent a car to take a statement from the guy or a report from the guy. Of course, no one was ever found in response to this. There's not enough information about the car until then as to what to look for. And there's so many of those vehicles on the road. Our position is Mr. Thacker was left to do this ad hoc. And that's not atypical of police situations. Police deal with dynamic, unusual situations. It is impossible to train them completely. I'm representing.
Let me ask you another question there.
Sure.
You say he's left to essentially his own devices. Is there any training for a dispatcher, or are there guidelines that are promulgated that are expected to be followed?
I have not seen them I didn't get that in the record. Admittedly, I was assigned this case less than 2 weeks before the hearing after the other lawyer was terminated. So I had minimal time to get ready, but I was not able to find him. I'm sure Mr. Ward, who's a fine lawyer, Mr. Smith's a fine lawyer, and it's been a pleasure, I'd like to add, working with him on this. Will correct me if I'm wrong, but I'm not aware of that. This is an unusual circumstance that I think is very difficult for a police officer working as a dispatcher to predict what to do. But that's the basis of his termination, is he created a liability situation for the city by not sending EMS to look for the guy and a patrol car to look for him. My position is they wouldn't have known where to find him other than the hospital anyway, because he was within about a quarter of a mile by Mr. Thacker's estimation when he called. He had walked approximately a mile, and Mr. Thacker, he told Mr. Thacker where he got hit. Mr. Thacker's from the area, he knows it. He told him he was walking to the hospital, and he estimated, well, he's been walking for almost a mile, so he's pretty close to the hospital. So he chose not to send the car until he got there, and that's the basis of his termination. Now, the judge or chancellor only focused on that incident. There was evidence of 2 prior disciplines that I mentioned in my brief. And I don't know if you even, because it was not addressed in the order, I'm not even sure whether to bring that up. I only mentioned it in my brief in case it did come up. But the 2 prior disciplines involved.
Mr. Tidwell.
Yes, ma'am.
Before you get into that particular issue, is there a dispute as to what ultimately resulted in an officer being dispatched to check on the victim?
I'm not aware of that. An officer went to the emergency room and interviewed the victim and took a report.
And your client alleges that, if I'm correct in remembering this, he told him to go on to he told the victim to go on to the hospital and then call back. Is that correct?
Yes, Your Honor, he did.
And is that what that your client maintains resulted in actually sending an officer over there?
Yes, Your Honor.
Okay.
And I'm about, obviously I'll answer any questions. As far as a prior discipline, I think both of those incidents are also very unusual. One is he failed to go to an FOP lodge, Fraternal Order of Police.
Let me stop you before you get into that, and I certainly want you to finish your thought here. But did the trial court rely on those prior incidences, or do we know?
It's not mentioned in the order, so I'm assuming I have to assume they did. And I hesitated to even include them in the brief, Your Honor. I think the issue before us is the incident we just described.
Okay. Go ahead.
No, I just would say that I mentioned them in the brief. If you want to refer to that, I think both of those incidents are very unusual. One is involving a Fraternal Order of Police lodge meeting that was allegedly mandatory. That's not a city facility. It was on a Sunday afternoon. He overslept and missed it. and the other involves him trying to take a person so intoxicated they couldn't communicate to the jail from the emergency room, and the jail wouldn't accept him. And they went back and forth, back and forth. And frankly, I don't know what else Mr. Thacker was supposed to do with that dangerous person who couldn't be turned loose on the streets, but put him in jail. The hospital wouldn't take him. He didn't need hospitalization. So he was disciplined or reprimanded for both of those events. I frankly wonder why the jailers aren't being disciplined for that, for not taking the man in. Leaving him on the sidewalk is not an option. So with that said, Your Honor, I would just simply say that we think there's a lack of substantial material evidence to justify the termination, and therefore it's arbitrary and capricious. And I'll end on that note and allow Mr. Ward and Mr. Smith to argue.
Yeah, let me ask you one question, Mr. Tidwell.
Sure.
In connection with the police arriving at the hospital, was it because of a call by the victim, or because your client dispatched the police, or because somebody at the hospital actually reported it to the police department and someone was dispatched and not by your client?
To my understanding, the victim called the dispatcher back when he got to the emergency room, and they dispatched a car. That's my understanding. I lack CAD traffic in the traditional sense of the recording and the computer notes to tell you that there's evidence to back that up other than my client's testimony.
Okay.
Because I don't think it exists, if I understand correctly.
All right, sir. Thank you. We will hear from the appellee, and of course, you will have your rebuttal time.
May it please the court, I'm Jeff Ward, representing the appellee, the town of Greeneville. As Mr. Tidwell's indicated, the standard for this court's review is it's a de novo standard as far as review of the evidence. So the court's reviewing the evidence de novo, but then it's a determination of whether there was substantial material evidence to support the decision, not the court substituting its judgment for the decision that was made, but whether or not there actually was substantial material evidence to support the termination decision. So stated another way, it's this court should affirm the termination unless it finds, based upon the evidence, that no reasonable person would have terminated Mr. Thacker. Mr. Tidwell's position on behalf of Mr. Thacker is that the conduct at issue just doesn't rise to the level of termination. The problem with that is all the people looking at this had to assess not only the conduct at issue, but Mr. Thacker's response to that conduct. So it's not only looking at the events that gave rise to the discipline, but it's also looking at Mr. Thacker's attitude in responding to the disciplinary issues. And Mr. Tidwell's done a very good job for Mr. Thacker. But
Let me stop you there. So how do we know what that attitude is or was?
Yeah, and that's based upon the record, Your Honor. The record itself will show you how he responded to the Civil Service Board, how he responded to questions about his conduct. And part of the problem here is when you've got an employee who doesn't
okay, I understand what you're saying, but before you get too far down the road, let me ask you, did the trial court or did the board or did any of those agencies that made decisions note that attitude or note his response?
And I'm not sure that they specifically said, we don't like his attitude or we don't like his response. So I don't know that that's delineated in the record someplace, Your Honor. I think it's only.
How are we even able to consider something like that?
Based upon the testimony itself, Your Honor, it's part of the record, it's part of the evidence. And the court.
I understand that part of it, but unless the trial court or the board or the decision makers relied upon it, how are we able to rely on something like that?
So I think the court's required to defer to the finder of fact if there's a factual determination on credibility of witnesses, those types of things. And that goes into what the Civil Service Board was seeing.
Was there a credibility determination made?
The Civil Service Board certainly determined that his conduct warranted termination based upon what they were seeing, based upon his response to it. And so
I understand you just answered a question, but it was not my question. And the question was a credibility determination made?
I don't know, Your Honor. I don't know whether the
What did
The
they
order-
say that we found someone to be credible or not credible?
I don't recall if the civil service decision says that or not. I can attempt to look for it, but I don't know that off the top of my head, Your
I
Honor.
mean, you were going in that direction, so I just wanted to know. I'm looking for the evidence. I'm looking for what was relied upon, not necessarily what we could rely upon, but what they relied upon.
So, and to do that, I think you've got to go directly to, if you're talking about what the Civil Service Board relied upon, you've got to go to their actual finding. And so the order says that that he was terminated on September 12, 2018 by the Administrator Smith following the recommendation of Chief Ward. That termination was based upon his conduct on August 31, 2018 involving a call for assistance by a citizen. And then they relate the events to that. And they say after relating the events that based upon the foregoing factual findings, the board concludes that Thacker has failed to submit evidence to the board to overturn his discipline by the town of Greeneville. The board finds that the discipline of Thacker by the town of Greeneville was not politically motivated, that the discipline was done in good faith for cause, and that the discipline was appropriate for the circumstances. So that's the order as far as what their findings were after relating the facts. They did say that although Thacker disputed and contested the validity of his prior discipline, the record reflects that he received progressive discipline prior to the event at issue. So that was their commentary on that. And they noted that the officer who investigated the circumstances determined that a much less experienced officer would have been expected to do more for the safety and well-being of the citizens. So those are the things that they reflect in their order. And I can't comment beyond that as far as what was going through their minds, Your Honor.
Well, and I don't expect you to, but I'm just, we were talking about a lot of what I consider to be esoteric things. And unless those esoteric things are actually noted by the board, I'm not sure it's proper for us to consider. But let me ask you a couple of specific questions. As opposed to opposing counsel, is there a job description or is there is there something that a dispatcher is given that said these are your duties and to guide them in that particular job description?
My understanding is that there is, Your Honor, but that is not part of the record. There was not a training issue raised at the Civil Service Board level. So Mr. Thacker wasn't claiming to the Civil Service Board that he wasn't properly trained.
Well, help me then, because what I'm hearing, and perhaps I have a misunderstanding of this. This call comes in. The officer makes a decision, and he explains his decision, and there's some discretion that's involved in this decision-making process, but we don't know how much discretion is involved because we don't have the parameters of what he's supposed to do. So how do we know if he did less than what he was supposed to do?
So based upon what was submitted, Your Honor, that was based upon the investigation that was performed, the recommendation of the officer, the recommendation then of the chief of police, all of which were making the determination that he clearly should have done more. Plus he received a counseling email approximately a month before that specifically told him that all calls were supposed to be entered into the computer assisted dispatch and dispatched as soon as possible. So there's that evidence in the record of that additional training to him and that additional admonition to him about a month before that all calls are supposed to be entered. And that's the problem here is he not only didn't enter the call, but he took no action whatsoever to assist either the citizen or to try to apprehend the person involved in the criminal act. So nothing was done at all, but for the fact that the guy eventually did make it to the hospital about 45 minutes later, that the hospital then called and then an officer was sent out. And that was the major problem, is that nothing was done and that any officer operating in a dispatch position should have known that much more was required. Now, to what extent, if he says the guy didn't need it.
Yeah, let me stop you there.
Sure.
And that evidence that any officer should have known, any officer acting in this dispatch capacity. Where is that evidence coming from?
So that's coming initially from the investigator that performed the investigation and his report and recommendation to the chief. And then that was affirmed by, I think, the chief at the Civil Service Board hearing.
I don't think I'm asking the question correctly, and I apologize for that. My question is, we're saying he violated this standard, or your position is he violated this standard. He didn't do all he was supposed to do. I'm looking for the standard he violated. I'm looking for who said this was not the correct response, and this is why this was not the correct response. What are they relying upon?
So they're relying upon the initial instruction to Mr. Thacker to input all calls into CAD. They're also relying upon the investigation performed and the recommendation of the investigating officer who investigated the circumstance. And that's part of the record.
What is he basing his determination on that the standard was not complied with?
I think based upon his knowledge of the duties of the dispatchers. So these are, the detective.
Was that ever explored, or was any evidence about what those duties were or how those were violated ever introduced?
Not that I'm aware of, Your Honor. I don't think there was any introduction of any testimony specifically saying a dispatcher does A, B, and C, or any written documentation on the role of dispatcher. So it's basically an expectation of what other officers believe a dispatcher should do is what's in the record.
Isn't that somewhat problematic here?
It's not from my standpoint, Your Honor. I understand if Your Honor has a problem with it, but from our standpoint, it was clear cut as to what Mr. Thacker should have done. And nobody thought that what he did was appropriate.
Well,
and he didn't
understand the people that reviewed it at that level didn't think it was appropriate. And that may actually be the case, but I'm still struggling with you got terminated because you violated your job description, but we don't know what the job description is other than this email that he got.
Well, and there's a reference, I think, in the actual termination decision as to the policies that they deemed it to be violative of, but those weren't gone into in any depth that I recall at the hearing, as far as saying that he didn't violate those. So it was a matter where they looked at the officer's conduct, determined it to be a clear violation of what he should have done, and then looked at his disciplinary history and said, based upon his disciplinary history. And
let me stop you there too.
Sure.
Did the trial court rely on his disciplinary history and the termination?
I think Mr. Tidwell is correct that the trial court doesn't say one way or the other.
So are we to consider this incident, this single incident, as one that we have to look at and say, if he's found to have violated this, then we have to determine whether this is a incident that he could be terminated for?
No, Your Honor, because what Your Honor is reviewing is the Civil Service Board determination. So it's a
service board consider these prior incidents?
Yes, they've considered the prior discipline and said, based upon the prior discipline, which it's in the record, this event was sufficient to terminate. So I think you're considering the record as a whole and then looking at whether
that. Yes, but I'm just trying to figure out who considered these prior incidences, if they were ever considered.
They were certainly considered as part of the initial recommendation for termination. That's in the chief's recommendation. They were considered as part of the termination. How much the Civil Service Board weighed these decisions or these prior, we don't really know. We just know they're referenced in the order. So those things were discussed, they were looked at. And I'd submit to you that if it was this single event, this single conduct, and you had a sterling officer who never had any prior problems, it likely would not have been a termination. It likely would have been something else. It might have been a written reprimand, a suspension, but that's not the context that the situation was in. It was one where there are multiple prior disciplinary issues. And the problem was Mr. Thacker never recognized any of the issues as a problem. So it's not a situation where he comes in, acknowledges that he made a mistake, promises to do better, promises to correct his deficiencies, but it's a situation where he had two events that rose to written reprimand and suspension in 3 months before, as well as a number of prior events that are all delineated in our brief for the court. So it's
Okay.
not a situation with a pristine officer, and that's the difference.
Thank you. Thank you.
Do we have a transcript of the testimony before the Civil Service Board in our record?
You do, Your Honor. And that's part of what I had pointed out to the court and why I was saying the court could consider his response, because when he was questioned about these things, he actually said, no, I don't think I deserve discipline for any of these,
Okay. All right.
which is very problematic, at least from my perspective.
All right. Thank you very much. Appreciate your argument. We'll now hear the rebuttal.
Your Honor, Mr. Ward had split time with Mr. Smith.
Oh, okay.
Hey,
I'm sorry.
please support Woody Smith on behalf of the.
I
Civil Service
apologize.
Board.
Nobody told me. I'm sorry.
No problem. And actually, I don't have anything to add to what Mr. Ward and Mr. Tidwell have told you. I'll be happy to answer any questions, but as the attorney for the Civil Service Board, I simply don't have anything that would enlighten you on any of the questions that the court has had so far.
I appreciate your candor, appreciate your argument, and again, apologize for failing to recognize y'all were splitting time.
No problem.
Thank you. Now we'll hear from the appellant in rebuttal.
Very briefly, I'm torn by this because while the Civil Service Board undoubtedly considered prior behavior, the judge didn't. And if I understand the narrow nature of this review, it's what the judge did, not what, as well as I know the Civil Service Board has looked at. However, just briefly on those incidents. One is a meeting at a Fraternal Order of Police Hall, which is not owned by the city. That's an independent agency, if you will, that was on a Sunday afternoon, and Mr. Thacker, who has diabetes, had taken some serious diabetes, had taken some medication, overslept. Okay, that's fine. I've never heard of an official meeting being held at the Fraternal Order of Police Hall here in Chattanooga, and I've represented police officers for 3 decades all over East Tennessee. But if that's how they do it, that's fine. But I don't know that that's really such a serious offense. Secondly, the incident at the jail is shocking, that jail officers would tell him to just turn a man so drunk he can't stand loose on the street and wouldn't accept him for public drunkenness. Thacker was called to the ER. He went there. The man was unable to communicate. They would not admit him to the hospital. He took him to jail. They sent him back to get a note. He brings the note back. They sent him back and said, you have to get a doctor to sign it. This is nothing but a snipe hunt, and it's explainable quite easily. This is what happens between sheriff's departments and police agencies. They have a natural competition with each other. They don't get along that well sometimes. And those 2 incidents are just not worthy of consideration, in my opinion. Secondly, his attitude is so subjective and such a subjective determination. I don't know how we look at that effectively. So that would be the total of my response or rebuttal. And I thank you very much, Your Honors, for considering this argument and listening to me today. We greatly appreciate it. And I thank Mr. Ward, Mr. Smith, for being such gracious hosts to me in Greeneville, Tennessee. It was a lovely trip up there. I love going to Greeneville, and I hope to go back.
Thank you. Gentlemen, we appreciate all your arguments. Again, apologize for the snafu there with the splitting of time with the appellees. We will take this matter under advisement, attempt to render an opinion at the earliest possible time. Again, we appreciate you participating via Zoom. We appreciate the hard work that Mr. Hibner and his staff, as well as the AOC staff, have worked so hard to make this possible. Mr. Hibner, if you would recess court to the call in the next case, please. You're muted, Mr. Hibner.
The Honorable Court is now in recess until 10:30 a.m.
Okay, thank you.
Thank you.